issues on appeal is the failure to instruct on lesser included offenses. We've raised a couple other issues, but I'll start with the lesser included. Specifically, at trial, the district court instructed on the lesser included of reckless second and involuntary manslaughter. That was the issue in the first appeal. We have argued in this appeal that the district court should have also instructed on second degree intentional and voluntary manslaughter as well. Second degree intentional was not requested below. Voluntary manslaughter was. So as we move through this, there will be differing standards for those two. I believe for both of them, you do have to answer the question whether or not they are legally appropriate.
Well, first you have to answer the question, why doesn't State versus Todd apply?
Well, I think that comes to my issue of whether or not they're legally appropriate. Certainly with Todd and the revisions to the felony murder statute, if Todd stands, that is for the proposition that there are no lesser included offenses for felony murder and that can be applied retroactively. It's our position that Todd should be revisited and overturned. If Todd is not, we would concede that that is a very large obstacle on our end. But from our perspective, Todd and applying it retroactively does violate the prohibition against ex post facto laws. I know that was raised in Todd, and this court found that it did not violate the prohibition against ex post facto laws. But with ex post facto laws, what we are concerned about is three kind of categories: making formerly innocent conduct criminal, enhancing or making more severe the sentence or punishment after the fact, and kind of the third one is whether or not it takes away defenses that otherwise would have been available at the time of the offense. At the time of the offense. And we believe by applying retroactively legislative amendments in this case, you are taking away defenses that Mr. Teja would have had at the time of the offense. Namely, the defense of convict me of a lesser. I'm not guilty of felony murder, I'm guilty of something less. So we believe for that reason it does violate prohibition against ex post facto, and those changes should not be applied retroactively. They should not be applied to Mr. Teja's case.
Was this case, I can't recall, but was it tried, or was the offense committed when Berry was in effect? State v. Berry, I think it was pre-Berry, wasn't it? I could be wrong about that.
The first trial was pre-Berry.
Okay, so there were the defenses in effect at that time?
Under Berry, you could have gotten lesser included
if
offenses.
The evidence of the felony murder wasn't strong, was that right? Or so there was some.
The standards were different, Your Honor.
Right.
But at the end of the day, you still could get lesser included. Applying the legislative changes retroactively takes away all lesser, regardless of the standard you're going to use. So we do still think it does take away those defenses. And I believe the timeline is the Berry came out, then the Supreme Court's opinion used Berry to reverse. And obviously the first trial was before Berry did. So from our standpoint, we believe this court, again, should revisit Todd and its finding that this is not a violation of the ex post facto prohibition against ex post facto law. Assuming...
Now, explain how that would have been a defense. It's always seemed to me that the lesser felony murder were more alternative charges rather than lesser included defenses. That you're really convicting the underlying felony.
I think they still are defenses in that you're saying, whether or not you're going to say, you're charged with felony murder and you're going to say this is only voluntary manslaughter. I still think that's a defense to the charge of felony murder. It's certainly a lesser crime, carries with it far lesser punishment. This court, I'm sure, sees all kinds of cases where the question isn't necessarily who did it, whether or not it's a murder or whatnot, but was it first-degree murder? Was it egg robbery? Was it just robbery? There are plenty of cases where people come to court and say my defense isn't that, some other dude did it. My defense is I didn't do what they're charging me with. I'm guilty of something less. Where you argue you're only guilty of lesser included offense. And certainly those carry great legal ramifications down the road as far as getting to sentencing. So we believe that still is a defense. It might be a little bit, felony murder is kind of a little bit unique, and certainly a little bit different when you talk about lesser included as a felony murder compared to where you have first degree, then you have second degree, etc. But I still think it's still a defense to the charge of felony murder. So, without being able to argue those defenses, we believe that there is a violation of ex post facto. Assuming this court goes along with me on that, kind of the next question is whether or not there's a factual basis, whether there's evidence to support giving these lesser included instructions. Just briefly, I think with second degree intentional, that certainly seemed to be kind of the focus of the state, the theory of the state almost. So we believe that there certainly was evidence to support a second degree conviction. I think the state essentially concedes that in their brief. With voluntary manslaughter, we believe there was a sufficient factual basis to give that as well. This is voluntary manslaughter, heat of passion. The district court did not give it because the court felt that there was a sufficient cooling off period between the provocation and then the subsequent killing. With voluntary manslaughter, it's whether or not the provocation is such that an ordinary person will essentially lose control, lose reason, lose thought, and act without thought or reason. Whether or not the cooling off period, the length of time.
What's the provocation? Seeing her dance at a bar 4 hours earlier? Is that the provocation?
That is the provocation, and there was certainly testimony to that fact that he did see her at the bar with another man. And there was certainly testimony after the fact that he was very distraught, very emotional upon seeing that. We believe, it's...
And then he went home.
Gathered some
loaded up
belongings.
his 270, got his dark clothing on, went over and sat and wait for some period of time.
That is correct. We still believe, though, that even with those actions and with that lapse of time, the question is one that we believe is a factual question for the jury. Whether or not an ordinary person after that amount of time would have cooled off. So we don't believe it's the district court's duty to make that what we essentially see as a factual finding.
That's what the statute requires a district court to do, doesn't it?
I guess I don't read the statute that way, Your Honor. I think the statute, when it talks about voluntary manslaughter, heat of passion, talks about provocation that would cause someone to lose control.
I'm talking about the statute regarding lesser included offense instructions.
Oh, I'm sorry, Your Honor.
And whether someone is a gatekeeper here, and that would be the district court, and he or she must decide whether a jury could reasonably convict the person of this lesser included offense. So the court, it looks like, made a determination here that no jury would reasonably convict because of the cooling off period.
And I guess my point to that, Your Honor, is again that is a factual question. At the outside, maybe there is a sufficient period of time, 2 weeks or whatever, I don't know, that you can say as a matter of law, that is insufficient evidence to support a conviction of voluntary manslaughter. I'm arguing that the time involved here does not meet that threshold. That the time period from when he saw his ex-girlfriend with another man at a bar and when the killing occurred was not sufficiently long that you could say as a matter of law, a jury could not convict him of voluntary manslaughter. So while the court is a gatekeeper, it is looking for evidence that a jury could rely on. And I think there was that evidence in this case to support a conviction for voluntary manslaughter.
Can I move you over to the opening instructions from the court to the jury and the notion about the expense of the trial and that sort of thing? Am I correct in looking at the material that neither side got an opportunity to look look at those instructions and object before the court gave them?
As far as my understanding of the record was, that was not, at the end of the trial, you kind of have these written instructions, you have a jury conference. My understanding there was not anything along those lines before those instructions were written. That those were just preliminary instructions the district court gave without consultation with counsel.
How do we, and the reason I ask is I'm struggling as to which cubbyhole to put the question in. If it's an instructional error, I'm having a hard time applying clearly erroneous to the defendant when the defendant didn't get a chance to raise their hand and object. You see what I'm saying?
Yeah.
So where are we with this issue?
From our standpoint, we raised it as a judicial misconduct claim. Even though it was an instruction, we believe that it was a judicial misconduct to give that instruction. So from our standpoint, we believe that the review is unlimited for this court, and that while, like I said, there wasn't really that conference that you have with instructions at the close of the case. I don't think defense counsel is in that same position to make that objection.
What's the misconduct? Is it not giving the lawyers an opportunity to review and make a record as to whether those opening instructions should go forward, or is it the content of the instruction?
I believe it's the content, Your Honor. This court has, in various cases, said that that type of instruction is misleading and inaccurate. And going back to, I think it's Salks was the first one. That's an 2009 case, and this district court still gave that instruction. The second trial was in 2012.
But let's say that's true. Let's say the case law was against giving the instruction. If that had been an instruction at the back end and there had been a instructions conference and the defense counsel had not raised that issue, we would still apply a clearly erroneous evaluation, whether failing to give the instruction would have given us a different outcome. So I'm having trouble figuring out if this is an instructional error, because it feels like it is. But what I can't figure out is what to do with it once it's an instructional error.
Right. And to the extent it is a preliminary instruction, that's probably why it certainly feels like an instructional error. As I said before, we've raised it in a different vein. But I think, once you look at it, you certainly, I think, then have to do almost a harmless error standard when you kind of determine whether or not it warrants reversal. And one thing I would point out with regard to this instruction that from our standpoint makes it a little more problematic in this case is that during voir dire, one of the potential jurors, I don't believe that juror actually sat, but one of the potential jurors did say out loud in front of all the other potential jurors that it was his understanding this was already a second trial. So we think this is a little bit more problematic than maybe some of the other cases out there, because the information about this being a second trial is already out there, and then you add on to that a district court talking about the expense and burden of further retrial.
Isn't there? Oh.
That's okay, go ahead.
Well, isn't there a distinction between a preliminary instruction and an instruction on how jurors are to behave during deliberations? I mean, what typically occurs during these pre-trial instructions once the jury is impaneled is instructions on how to behave. We're going to start court at 8 o'clock. We're going to take a break. Here's what admonitions I'm going to be given. Here's your responsibilities. You can take notes. You can't take notes. All of the things that jurors are not aware of and what their responsibilities are as they undertake the responsibilities of hearing the case. And so it's kind of like, okay, don't mess around here. Here are the rules, and if you mess up on these rules, I might have to declare a mistrial, and that is a great inconvenience. And it is an expense, and maybe the expense shouldn't be, but you have some certain responsibilities and duties that you're sworn to uphold during this process. And I think that's a lot different than saying at the end of deliberations, and now you're about, or at the end of hearing the evidence, now you're about to deliberate. Now, as you decide this case, I want you to take it seriously because anything that happens in here could result in mistrial and could be an expense. That I just think there's a distinction between the two procedures. In fact, a big distinction.
I guess I would disagree with the court on that because I think it's still very problematic to talk about cost and expense of a trial, the cost and expense of a defendant exercising his constitutional rights. And if you have to redo it again, that is something to be borne by, and the phrase they're using is taxpayer, which are the jurors themselves.
Well, it appears to me that the trial court tried to fashion this after PIC 50.010, which is the cautionary instruction for impaneled jurors. Wanted to talk to them about their misconduct, and they could be held in contempt. And there's a PIC instruction on that, but the court went further and added to the PIC instruction. And so it's not that it wasn't appropriate to give the cautionary instruction up front, because PIC says it is. It was just the content that the court added. And so back to Justice Biles' question, did the defense have any obligation to object and give the court an opportunity to correct its incorrect statement? Or do we review this as if it was preserved and everything's okay?
From our standpoint, we believe that this court should review it as if it was properly preserved, because again, I don't believe that there was any conference where these preliminary instructions were discussed that would give the
But there was nothing to preclude the counsel from objecting to the content of the cautionary instruction, was there? So get the court to correct that at the particular time.
when the court made the instruction to
Right.
stand and object.
Right.
I don't believe that there's anything that would have prevented counsel from doing that. I would, unless there are questions on, we also raised the prosecutorial misconduct claim. I'm out of time unless
Before you continue, yeah, I think pretty much this was covered by my colleague's question, but I'm focusing again on the content of what was said. It was in a different context. It wasn't just different timing, it was in a different context, wasn't it here? It was directed at juror misconduct as opposed to the pattern of deliberations.
I think if my memory serves right, as far as Salt's was, I think it was more in the line of an Allen type instruction, where you're at the back end.
Right.
Here, the context was juror misconduct. And the court certainly can give admonitions about what the jurors can and cannot do. I think where that crosses the line for us is when the court then goes on to talk about, if we have to do this again, the cost and expense. And I don't think that is appropriate to tell the jurors about that. That, I think, brings into play things they should not be considering.
They should consider it if it's their misconduct at issue as opposed to something the defense has done. I mean, this is what I'm suggesting. The context, not just the timing, but the context may make a difference in analysis. Because he or she, the judge is trying to prevent the jurors from engaging in behavior that would cause a mistrial. At the end, when it's a deadlock-breaking instruction, then he's talking about deliberations and about consideration of the evidence. And that shouldn't make a difference.
There is a difference, but I don't think it is different that makes this preliminary instruction we're talking about here appropriate. The court, again, can certainly tell a juror you can and cannot do these certain things. If you do, it could result in a mistrial. But it should not then go on to talk about the expense and the burden of that, what would be a retrial. Again, we think that kind of brings into play things that are beyond what the jury should be considering. The jury should be following the district court's order, weighing the evidence, coming to a conclusion based on that. So we think that the district court in their preliminary instruction went beyond that and was an error.
Well, we don't care if the jurors think about that before they do something untoward or something prohibited. The only bad part of it is if they translate that into their deliberations. I mean, that's the only place that it may cause concerns, because we certainly hope they think about all these bad things before they take it upon themselves to do something they've been told not to do. But the only culprit out of this thing would be that in deliberations, if they would translate that initial cautionary behave yourself instruction as also applying to the deliberations. And why do you think that would be a natural consequence for a rational jury to make that connection?
In the course of the preliminary instructions, the court is telling the jurors how to conduct themselves throughout the trial. And the court tells the jurors, these instructions carry the day throughout the trial until I give my final instructions. So those are guidelines the jury has throughout. Even though they're giving at the front end of the case, it is guidelines for the jury from the time they're sitting in the box until the time they're in the deliberation room. So we think it does come into play even at the back end, despite the fact that these were preliminary instructions. And again, it brings into play what we think are improper considerations. We did raise a prosecutorial misconduct claim. Unless there are questions, I would submit those on the brief. And we would ask you to once again reverse Mr. Teja's conviction.
Any more questions? Thank you, counsel.
Thank you.
Good morning. May it please the court. Natalie Randall, Ford County Attorney for the Appalachian State of Kansas. Any issues we don't hit on, we will stand on our brief in place of argument for those. I had not come in particularly planning to spend much time on the underlying offense issue. I would like to hit on it just briefly since there was some argument made in support of trying to reconsider Todd. The felony murder convictions have always been an interesting factual thing to look at, because if you did have a jury who was willing to consider heat of passion played a role in a case like this, the heat of passion doesn't play into the underlying felony analysis. So you still have a jury finding that the act of intentionally shooting occurred, and the death is the only other element you have to prove. So it's sort of interesting that even if the judge were wrong, which we submit he was not, Mr. Teja not only spent quite a bit of time between the moment when he saw her dancing with this other man at the bar until the killing occurred, he actually took a nap. There was a nap in between there. So the judge simply did not get that wrong. But even if he had, and there was some evidence to support this heat of passion, it's just an interesting thing to consider is if the jury has found him guilty for intentionally shooting, and again, heat of passion doesn't play into that statute for analysis, and then we've shown that the victim in this case died, you've met your elements for felony murder. So it's just interesting now.
So it's been an uncomfortable fit.
It is an uncomfortable fit, and I think now with the statutory scheme having been revised and Todd coming out stating that that was not an ex post facto problem, it's probably something we won't be grappling with much more in the state of Kansas, but I did want to hit on that just briefly. In regard to the issue with the instruction that the court gave, it appears to me that the better practice would have been to follow the framework of PIC. Since SALT and some of its progeny, there have been a couple of developments, and it seems to be that the issue and the concern with giving an instruction like that has broadened to where it's likely that it's probably not an appropriate thing in terms of getting into it with the jury about the expense of a second trial. However, if ever there was a time to find that it did not interfere with or place undue pressure on the jury in regard to their deliberations, this certainly fits that category. This was a week-long trial. The instruction was given before evidence was heard. It was given in a context very separate and distinct from their deliberations. And so even if the court finds that the language or the concern about pointing out to jurors the expense of a second trial may be ill-advised, this case appears to me to fall into a clearly non-prejudicial in terms of tainting the jury in the Saltz-like concerns.
Counsel,
So-
do you agree that during the trial, the defense counsel didn't have an advance opportunity to take a look at that instruction, and so the only thing to do would have been to throw a flag in the middle of the play?
I agree, and I think that's true for many different issues that have to be raised in order to preserve them for appeal, or that result in a different standard on review, that sometimes it does have to be raised after essentially the cat's out of the bag. But there wouldn't have been anything that, to my knowledge, stopping the defense counsel from objecting and asking the judge to modify his instruction at the point that it was given. Honestly, I think the record's silent on whether the parties were aware of the instructions before they were given, but since they weren't submitted in the case as written instructions, probably not.
So what is our standard for determining whether that's reversible error?
What we look at is if it's clear error, if we're going on they should have raised an objection. If not, there should be there should at a minimum be a showing that it would have had an impact on the jury in terms of placing undue pressure to resolve their differences, if you will, in regard to deliberation. As far as the actual instruction itself, I don't think in the context that it's given that it could be framed as improper. I think the problem we're running into is if the jury harkens back in their mind to this issue at the point of deliberation, is that then causing them to somehow think they have to give in to pressure or, vote with the other jurors maybe that they might start off disagreeing with because the court has then said, well, it's going to cost somebody something. So I would argue that the standard is clear error because there is an opportunity to object, even though it may not have been a pre-notice to the parties. Obviously, the parties were present and either side could have objected to instructions being given. So I believe that's the standard. If we're looking at the practical implications of it, then I think we get to the point where it could be a case-by-case analysis. In this particular case, the record reflects the jurors never deadlocked. The jurors sent back two very brief questions, and by and large, the jury deliberations proceeded without any known or apparent concerns about that particular issue.
The reason I asked that, there's been some discussion this morning about this being raised as a judicial misconduct issue, but it sounds from your answer you're regarding it as an instructional issue.
I do see it that way, Your Honor, and again, like any of the other instructions that the court gives at trial, the difference here being is whether or not the parties had an opportunity to object, but I would submit there's almost always an opportunity to object. Even during closing arguments, sometimes we object, and the court can then instruct the jury to disregard certain things. So I believe we're definitely in the instructional error question, and I also believe there was some duty on behalf of the defense to object if they didn't care for that instruction.
And what if we felt differently and said, no, it's not a clear error standard because there was no opportunity to object at that time? What is your response in terms of reversibility on that standard?
My position on that would still be the same in regard to looking at the outcome or the effect of the instruction and whether or not it had any clear indication as far as weighing unduly in the minds of the jurors at the time of deliberation. And based on the remoteness and based on the context of this particular statement, I would submit if this had been given during a deadlock question, we would be in a completely different situation. But because of that, I think the totality of circumstances and looking at the context, this particular case doesn't probably give rise to any concerns about undue influence over the jury. Harmless, thank you. If there are no other questions on the instructional issue, I will just briefly get into a couple of points on the prosecutorial misconduct claim. the appellant argues that one of the statements by the prosecutor in closing, and specifically called, they referred to it as hunting, that the prosecutor had said, oh, I'm sorry, excuse me, it was in opening statements. The prosecutor had said he was going, he had gone hunting for the victim, Aaron Jones. The appellant's brief paints a very colorful picture in regard to what kinds of things or nuances that could raise in the minds of a juror when they hear the statement. But in reality, the prosecutor's statement was somewhat fleeting, and it really was not improper when you consider how you characterize hunting. And so in looking at that, plain definition is seeking or going to look for something is hunting. But even if you go into the context of lying in wait type hunting, which appellant argues was an improper statement given what the facts would be in this trial. And again, this is opening statement, so there's an anticipation by the state of the evidence that they plan to introduce. You have here a case where the defendant said that these events occurred approximately 3 weeks after the breakup. So from the time that Ms. Jones told Mr. Tejas she no longer wanted to be in a relationship until the time she died was 3 weeks. One of the state's witnesses was a marksman from the local police department who stated that Mr. Tejas had approached him 2 weeks before the Aaron Jones killing, asking about recommendations for a rifle that would be good for sighting things in, lying in the brush, shooting from, in the bushes type situation. So just 2 weeks before the killing, he's seeking advice from a fellow officer in regard to what kind of weapon would be appropriate for a hunting type situation. And then the evidence goes on to show that sometime within that 2 weeks, Mr. Tejas purchased the rifle. He may have shot it at the range a couple of times. It's the rifle he says he used to kill Aaron Jones, and then the bolt disappeared. So while he's himself characterizing it as a rifle that would be good for a hunting type scenario, and then is using that as the murder weapon, at that point he disposes of a portion of the rifle that makes it inoperable. So the only evidence we have in this case is showing that Mr. Tejas in his own mind is characterizing his thought process of how he wants to use this rifle in analogizing it to hunting.
What difference does it make, though? I mean, I think that's the point of the defense, is I can understand the argument if the criminal charge was different, but you got felony murder here. You don't need any of this stuff. And so it seems like you're talking about aspects that I think would be fair play in a different context that are not fair play because of the charge that you pursued.
And I'm not sure they're not fair play, simply because they're not required to be proved. I don't believe it automatically makes it improper to go there. Felony murder is a replacement method of proving premeditated intentional murder. But I think if you have evidence that also shows thought ahead of time, because you have to remember we still have to prove he intentionally shot into an occupied dwelling. So there's some element here of what is his intent, and was it to terrify her?
Isn't relevance something that makes it more probably true what you're proving than not? And you're proving that he's shooting into a dwelling, not that he's hunting her.
Right.
Because if he was hunting her and intentionally shooting at her, it would be a different crime.
It would be a same crime, but under a different scheme or a different statutory element of proof. I guess what I'm trying to submit to the court is I'm not so sure that proving premeditation elements is improper simply because the state's pursuing a felony murder theory of guilt. But also, when you look at any case where a crime's been committed, motive is something that's been properly shown. And so and sometimes in this case, and many would say it appears, if his motive was to terrify her, they'd been broke up about 3 weeks, he was a police officer, if someone was doing things to vex her or frighten her, maybe in his mind he thought she would take him back. So the plan part of this may very well go to his motive and intent in regard to shooting at the house, whether or not he thought he was going to actually strike and kill her. Many argued, and I believe this came out of both trials, that it would be very difficult for him to have made that shot accurately under the circumstances that he did. Perhaps this was a a very bizarre and very unfortunate outcome to something else that was intended by Mr. Tejon, which potentially was to terrify the victim. So there's that. But again, I'm not sure I would, I don't know of anything that says it's improper per se to overprove or prove additional elements that aren't required of the state, simply because they might tend to prove something that's even more difficult to prove.
You touched on an interesting point a minute ago about proving motive.
Yes.
Is that a requirement?
Motive is not required, but in almost every criminal case I've prosecuted, there's been something in the case that tends to show why. Why was this done? Motive is something that is a question that may hang over the minds of jurors, even though it's not an element in their instructions that has to be proven. And I don't believe there's ever been a case that said proving motive is somehow improper just because it's not an element of the crime.
Before I run out of time, I
Yes.
want to get to the inconsistent statement. You would agree that the state has the burden to prove these charges.
Correct.
And I'm having a little trouble finding the inconsistency in the statement that I wasn't there. But if you don't believe me on that, the state has failed to prove that the shooting wasn't an accident. Now, why is that inconsistent?
In terms of arguing to the jury that those are inconsistent theories, I'm not sure I understand the question.
Well, you argued in closing that the defendant can't have it both ways, but the defendant can have it both ways. The defense can say, my theory of defense is I wasn't there. But the state has the burden to prove to you beyond a reasonable doubt the charges, and even if you don't believe me, the state has not proved that this wasn't an accident. And that's not having it both ways. That's totally permissible.
Right, you're absolutely right. And it doesn't appear to me that the prosecutor was trying to argue that this was legally improper, but simply pointing out to the jury logical fallacies or improbabilities in
Why
regard
is that
to...
illogical? What I just said to you, why does that defy Aristotle?
Well, the part that's illogical is that in one scenario, the defendant's not there. And in the other scenario, he is there. So we only get to that question of whether or not it was an unintentional shooting if we can resolve those two dichotomous facts.
That would be a good argument if the defendant had to prove what happened, but the defendant has no obligation to prove what happened.
Right. But the state is properly relying on a statement of the defendant when he admitted killing her, and then being able to draw out things that tend to impeach or draw into question his credibility when he testified at trial. And those are proper
I think you
arguments.
were totally within your wide latitude to argue that the defendant made inconsistent statements. But I didn't understand that to be the argument. That you don't consider, you said don't consider the lesser included because the defendant can't have it both ways. That's different than saying you can't believe the defendant because he made inconsistent statements.
Right, and I think the appellant's brief couches it that way, but if you look at the actual transcript of the closing argument, the prosecutor was not directly talking about any of the possible lesser included. He was summarizing the evidence as a whole, and then he gets into this argument about he wants to have it both ways. He was either there and it was an accident, or it wasn't there at all, and there's a factual, illogical argument to be making, especially from the same person who has the same perspective on the facts of the case.
So this comment wasn't in regard to lesser included, because I was going to ask a question about how it could be harmful error or reversible error if no lesser included were.
The lesser included had been determined to be given, because even though there's an appeal on that issue, the judge did give lessers here. And I do believe the thing that makes me think the prosecutor was not intending to argue against the law that there shouldn't have been lesser included is that he says at one point during the objection, yes, I understand, Judge, and I know that the lessers are coming in. But don't believe he was trying to argue the lessers were improper or there was a legal problem. I think he was simply trying to point out an illogical argument in order to show the jury that either the defendant's testimony couldn't be trusted or just simply to redirect them back to the confession that he originally gave.
But after the objection and the court sustaining the objection, the prosecutor went on to use the Lee Harvey Oswald analogy.
He did. I think the better practice would have been to completely move on to something else. However,
But how is that analogy not improper?
the analogy again to me is something that causes me to think this was simply a factual challenge by the prosecutor. He's trying to give them a fact scenario that he believes fits the argument that they have to resolve, which is, do we want to believe the confession statement or the testimony, or throw them all out and rely only on other evidence? So it appears to me that he wanted to give something to leave them not confused about the issue.
Is there anything legally improper about this defendant saying, I wasn't there, I wasn't the shooter, and at the same time saying that if there was a shooting, it was accidental? Legally. Can you take those alternative positions legally?
Yes.
And does that affect taking those alternative positions? Does that affect the lesser included offenses?
It did before Todd. Theoretically, yes, that could affect which lessers are given.
Why? Because we don't determine the giving of lesser included based on the theory of defense. It's based on the evidence.
Well,
And the jury has to decide which crime was committed based upon the evidence.
right, but that evidence would include, when the judge is looking to see if there's any evidence in the record to support an underlying offense, that would include evidence presented by both sides. And in the state's case here, one of the defendant's statements was state's evidence. So that would certainly be one of the statements the judge would take into account in regard to determining, is there any evidence to support a lesser?
In this crime, what evidence did the defense present on a theory of defense that it was an accidental shooting?
At the time of trial, nothing.
Any further presentation?
No.
Any more questions?
Thank you.
Thank you, counsel.
I'd like to just address the point about the last discussion about the closing arguments. And I'm looking at volume 7, it was page 84. And starting on line 6, I believe is the record that we're talking about here. And that states, this is the prosecutor in closing arguments. There are some lesser included instructions that the court gave you. Aristotle, the great philosopher, wrote extensively on logic. He concluded that two contradictory statements cannot coexist in truth. In a layman's term, you cannot have it both ways. So he talks about Aristotle cannot having it both ways. Right after he says the court gave you lesser included. That's where we see the problem. He can't have it both ways. He can get those lesser included, and he can't argue he didn't do it. So we believe that was a misstatement of the law, and in this case, pushed the jury to convict and was prejudicial to Mr. Cahill.
And if you lose on your Todd argument, do you also lose on that in terms of any problem?
I don't believe so, Your Honor, because if it's reversed, the issue of whether or not it gets lessers, I think is different than the question of whether or not those statements, given the fact the court did give lessers, was harmful and warrants reversal. I think you have to look at it at the time that those statements were made. And at that time, lessers were being given. So I believe it is harmful, and even though, depending on what you guys do with Todd, at still would warrant reversal. It still is prejudicial to Mr. Teja at that time. He had a right at that time for the jury to consider those lessers. And the state, by implying that it was improper for the court to give lessons, for Mr. Teja to get lessons, we think was harmful and warrants reversal. If there are no other questions, I would again ask this court to reverse this for a new trial.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.